A $10,000 penalty slapped on a self-represented litigant. Fancy lawyers think they've sealed the deal. But then, poof, victory vanishes when they fail to follow their own rules. Stay tuned for a story where the underdog knows the courtroom playbook better than the pros. Hi, I'm Leela from Courtroom 5, and this is Who Wrote That Up for You, a show about real stories of people navigating civil court without lawyers. Each episode explores the challenges, victories, and setbacks of self-representation, revealing how some pro se litigants beat the odds while others fall short, and what can be learned from both. Today's episode features Triantos versus Guaetta, a case that flips the script on what it takes to win in court. Spoiler alert, it's not always about having the best arguments or the fanciest lawyers. Sometimes it's about knowing the rules better than anyone else in the room. Let's start in 2014, when Nicholas Triantos lost his home to foreclosure. Like so many others, he fell behind on his mortgage, and Deutsche Bank took the property. It's a heartbreaking but common story. But Triantos didn't give up. In 2017, he decided to fight back. He filed a federal lawsuit against Deutsche Bank and their high-powered attorneys at Guaetta and Benson. His claim? That Deutsche Bank didn't have the legal authority to foreclose on his home. The bank and its lawyers responded quickly, filing a motion to dismiss. They argued that even if Triantos' claims were true, they didn't amount to a valid legal case. The district court agreed, and the case was dismissed in September 2017. Triantos appealed, but the appellate court upheld the dismissal. By early 2020, it seemed like the story was over, but Triantos wasn't done yet. And the lawyers at Guaetta and Benson? Well, they weren't done either. But not in the way you'd expect. After the case was dismissed, Guaetta and Benson went after Triantos for sanctions. They used Rule 11 of the Federal Rules of Civil Procedure, which is meant to prevent frivolous lawsuits. If a lawsuit has no legal basis, Rule 11 allows the opposing side to ask the court to penalize the person who filed it. But Rule 11 has strict requirements. Before you can hit someone with sanctions, you need to file the motion separately from other filings, serve the motion on the opposing party before filing it with the court, wait at least 21 days after serving it, the safe harbor period, so the other party has a chance to fix or withdraw their claims. Guaetta and Benson filed their motion, but failed to follow the Rule 11 procedures. Nonetheless, at the hearing on the motion, the judge issued a one-line order. Sanctions granted under Rule 11. No explanation. Just an order for Triantos to pay $10,000 in attorney's fees and $532 in other costs. Triantos appealed. On appeal, Triantos didn't point out in his written brief that Guaetta and Benson had botched the Rule 11 procedures. Normally, missing such a crucial argument in your opening brief can sink your case, but something happened that changed everything. Triantos came across a case where the appellate court had reversed sanctions because lawyers failed to follow the Rule 11 procedures. Triantos realized that Guaetta and Benson had made the exact same mistakes. Armed with this new understanding, he brought up the procedural flaws during his oral argument. Now, you might think that raising new arguments at that stage would be too late, and it usually is. But the appellate court made an exception here. They decided it was fair to consider Triantos' points because Guaetta and Benson weren't caught off guard. They had an opportunity to explain themselves during the hearing, but did not. Since no unfairness was created, the court allowed Triantos' argument to proceed. The appellate court used a four-part test to review the case under the plain error standard. 1. Was there an error? 2. Was the error obvious? 3. Did it affect substantial rights? 4. Would letting it stand harm the integrity of the judicial process? All four factors pointed to a problem. Guaetta and Benson had failed to follow the rules, and the district court hadn't corrected them. Here's what went wrong. Timing. Guaetta and Benson served their Rule 11 motion after the case was dismissed. That violated the safe harbor rule, which exists to give the other side a chance to withdraw their claims before sanctions are even filed. Once the case was closed, there was nothing to withdraw. Service. Rule 11 requires serving the motion on the opposing party first, and then waiting 21 days before filing it with the court. Guaetta and Benson didn't wait. They served and filed simultaneously through the court's electronic system. The appellate court made it clear Guaetta and Benson had ignored two critical steps. And what about the district court? It made mistakes too. Rule 11 requires judges to explain why they're imposing sanctions. But the district court's one-line order didn't say what Triantos did wrong or why the $10,000 penalty was justified. The appellate court refused to guess at the judge's reasoning. Instead, they reversed the sanctions entirely. That $10,000 penalty? Gone. In the end, Triantos' discovery about Rule 11 turned the tide in his favor. His ability to connect the dots and use that information at the right moment became a pivotal part of his victory. Here are some takeaways from this case. 1. Courts might give some leeway, but learn the rules. The appeals court specifically noted that they cut Triantos slack because he was pro se. This doesn't mean you get a free pass, but it does mean courts understand you're learning as you go. Use this to your advantage, but don't rely on it exclusively. 2. Scrutinize the rules. When facing any legal challenge or motion from opposing counsel, always scrutinize whether they have strictly followed the relevant procedural rules. Don't assume that lawyers, even with expensive legal educations, always get it right. Whether it's a specific rule like Rule 11 with its requirements for a separate motion, proper service, and a safe harbor period, or any other procedural regulation, challenge them to prove their compliance. Understanding and enforcing these procedural requirements can be a powerful tool, as demonstrated in this case, where a pro se litigant successfully challenged a sanctions order by highlighting the opposing counsel's failure to adhere to the rules. 3. Challenge bare-bones orders. That one-sentence order imposing $10,000 in sanctions? The appeals court said that wasn't good enough. Courts have to explain their reasoning, especially for sanctions. If you get a minimal order against you, that's often grounds for appeal. Remember, you don't have to be a lawyer to understand the law. You just have to be willing to learn it, one rule at a time. How would you have handled this situation? Add your comments below. This has been Who Wrote That Up For You? Goodbye until next time.
Yeah, yeah.